Okay, this is the one that I'm going to use a witness to demonstrate for. So don't ask a question when you don't know what the answer will be. Okay, this is something you'll hear frequently from trial lawyers. They'll say, don't ask a question when you don't know what the answer will be. And the fact of the matter is you are going to know what the answer is because you have done a lot of preparation ahead of time to find out what the facts are. And you've also, of course, heard the direct examination. So you have you're pretty sure what this witness saw and didn't see, and you know what kinds of questions you can ask and what you can't ask. But you don't want to ask why, especially, can be a really dangerous one, or even what happened next. That's too open-ended. Those kinds of questions would work perfectly on direct examination, but they can get you in trouble. And we've had a police woman testify. That's Burton, and she has testified about why she thought my client had been drinking too much and about how she arrested her, etc. Now here we're at the trial. So I'm going to cross-examine the police officer and try to make it seem like he or she, in this particular case, didn't really have reasonable grounds to think that my client had been, was impaired in any way. So I'm going to start off and let's see. Are you ready, girl and Tom?
Yes.
Okay, officer, let's see. Now, when you pulled over the defendant, were the red and blue lights on your car flashing?
Yes, they were.
Did the defendant stop her car right away?
Yes, she did.
Did she pull over safely?
Yes.
Was she staggering when she got out of her car?
No, she wasn't.
Did she had her driver's license in her hand, right?
Yes.
Her license was valid, right?
Yes, it was.
Was she standing up straight?
Yes, she was.
Okay, so far I think I'm painting a picture of a young woman who doesn't seem to be impaired based on her knowing the rules, pulling over, getting out, having her license, standing straight, not staggering. So I'm hoping that I'm casting some doubt in the jury's mind that she actually appeared to be impaired. But now I am going to ask that one question too many that I probably shouldn't ask. Hey, officer, what happened next when you went up to her?
Well, she looked at me and said, "Hey, cool lights, what disco is it?"
Thank you, witness is dismissed.
You're welcome.
She'll be back again. So what I've done now is I've taken a situation where I have somebody who comes in police lights, gets out of the car and says, "Cool lights, what disco is this?" Which has completely destroyed any benefit I have of making it seem like she wasn't impaired. I mean, who is going to be pulled over by a police car, get out of it and think it's a disco? No one. If I had just left it where I knew what the answers were and not gone, maybe I actually do know the answer to this. Maybe I read in the police report and I don't want to mention it, you know. If she had already mentioned it on her direct examination, I might be in a little bit more trouble, or I might have to think of a way to get around that. But you don't want to bring up the bad facts yourself for the first time in cross-examination because you asked one question too many. That's not something that you want to do.